We are going to start things off, though, with the continuation of the trial of Kyle Rittenhouse. If you watched any of it yesterday, geez, Vlad, it was emotional. Not just Kyle Rittenhouse was quite emotional, so emotional, in fact, he had to leave the stand to compose himself before he could continue his testimony. But the judge was very emotional, and he really laid into the prosecution several times during yesterday's court hearing.
Yeah, and that trial continues today, Anne-Marie, in Wisconsin. After what you called a dramatic day in court yesterday, the 18-year-old is on trial for killing 2 people and injuring another at a Black Lives Matter protest in August of last year. As you say, Anne-Marie, he became overwhelmed at one point while testifying yesterday, telling the jury that the shootings were done in self-defense. Now Rittenhouse's lawyers are calling for a mistrial after they say the prosecution crossed the line while questioning the defendant. The judge also rebuked the prosecutor's tactics. Nancy Chen reports from Kenosha.
Yesterday was the first time that jurors heard from Kyle Rittenhouse, some appearing sympathetic as he broke down on the stand. Rittenhouse testified for several hours, telling the court he felt he had no choice but to fight for his life.
There were 3 people right there.
Kyle Rittenhouse broke down on the stand Wednesday, shortly after he started to detail his encounter with Joseph Rosenbaum, one of the 2 men he shot and killed August 25th, 2020.
That's where I run.
We're going to just take time for our break anyway.
The judge paused the trial to allow Rittenhouse to collect himself. His mother watched in tears. Later, Rittenhouse defended his actions, saying he shot Rosenbaum about 4 times.
The person that attacked me first threatened to kill me.
Rittenhouse says he then tried to get to the police as protesters began to chase him.
Why were you trying to get to the police?
So I didn't do anything wrong. I defended myself.
Rittenhouse says as he was trying to get away, the second man he shot and killed, Anthony Huber, hit him with a skateboard and tried to take his weapon.
He grabs my gun and I can feel it pulling away from me, and I can feel the strap starting to come off my body.
And what do you do then?
I fire 1 shot.
Rittenhouse says he shot a 3rd man, Gage Grosskreutz, the only surviving victim, because Grosskreutz had a pistol and was standing over him.
I was never trying to kill the defendant.
You intentionally used deadly force against Anthony Huber, correct?
Yes.
You intentionally used deadly force against Gage Grosskreutz, correct?
Yes.
With regard to Joseph Rosenbaum, you fired 4 shots at him, correct?
Yes.
On cross-examination, prosecutor Thomas Binger tried to paint Rittenhouse as the armed instigator.
Mr. Rittenhouse, you're telling us that you felt like you were about to die, right?
Yes.
But when you point the gun at someone else, that's going to make them feel like they're about to die, right? That's what you wanted him to feel.
No.
Don't
get brazen with me.
When it was the prosecution's turn to question Rittenhouse, the judge interrupted several times, calling out the prosecutor for questioning Rittenhouse's silence after his arrest and attempting to bring in evidence the judge had previously ruled inadmissible.
When you say that you were acting in good faith, I don't believe that.
After the exchange, the defense sought a mistrial, but with prejudice, meaning Rittenhouse would go free and could not be retried for the shootings. CBS News legal analyst Rikki Klieman.
What the defense suggests is that the prosecution, knowing it was losing, was actually purposefully doing misconduct so that it would cause its own mistrial in order to get another crack at the case. But all in all, the prosecution at this level of experience should know better than to do either of the 2 things that it did.
The judge was not willing to rule on whether he would grant a mistrial yet, but if this trial does continue, the jurors would likely get this case early next week. And if convicted of homicide, Rittenhouse could face life in prison. Vlad and Anne-Marie.
All right, Nancy, thank you very much. Rikki Klieman is here now to offer analysis of this trial. So, Rikki, let's begin where you ended with Nancy in your interview. What do you make of the prosecutor's tactics? It does strike me, and the defendant's lawyer mentioned this in court yesterday. He pointed out that the prosecutor is an experienced litigator. He knows what he's doing. I saw on Twitter from people who are lawyers that what he was admonished for from the judge is something that they teach you like in, Law School 101. So why would he do that, especially after he was given a warning from the judge?
As I mentioned when I was talking with Nancy, there is an argument that certainly many lawyers have put forth yesterday afternoon that the prosecution may have believed that it actually was losing the case and that it wanted to do something improper in order to force a mistrial with the ability to start all over again. Frankly, I don't believe that. I think what happened was the prosecutor, without thinking very much, because he had excuses for what he did, went forth on two different tracks. So let me explain the two. The first that got the judge so upset was that the prosecutor was, in essence, using questions to comment on the defendant's sacred constitutional right to remain silent, to not incriminate himself. You must never, ever comment in a courtroom about a defendant's silence at the time he is approached by the police, at the time that he's arrested, or at any point in time before he ever testifies. And then you can only cross-examine on that testimony. You just can never approach commenting on the right to remain silent. And as I said, and I think I was pretty fiery about it, I really believe that that went beyond the pale. And as you say, many lawyers say, this is lawyering 101 that you're taught. You just don't comment on that. The second thing that the prosecutor did that I think pushed the judge over the edge completely was the fact that the judge had previously ruled in a pretrial motion and apparently reiterated his ruling earlier yesterday that there was a whole area that the prosecution was not allowed to go into. And what that area was about, it's what we call propensity evidence, which lay people would understand better as character evidence. That if Kyle Rittenhouse had, in fact, at some other point in time, made a comment about the looters during these Black Lives Matter protests, that he wished he had a gun, that he wished he could shoot them, or any words to that effect, that kind of a statement, which had no action following it, which wasn't the case in a self-defense situation, that had no place here either. It's the old story, Vlad and Anne-Marie. Perhaps I can make it simpler. If you committed a burglary, and then 10 years later, you committed another burglary, but it was completely different. One was a smash and grab from a jewelry store. The other was creeping into a house. Well, the judge is not going to let in that 10 years ago burglary that was a smash and grab because it's too, what we call, unduly prejudicial rather than relevant. So that's the best way I can explain it. And the prosecutor should have known better. This is a very experienced litigator. He went ahead on both tracks, and it sent the judge over the moon. Now, I know people on various networks have been very critical of how the judge reacted, but you have to remember this reaction was outside the presence of the jury when he really hauled off at that lawyer. And I've heard commentators who are lawyers saying, I've never seen such a thing. And I thought to myself, well, then you haven't tried as many cases as I have. I remember a day in court where a judge almost came across the bench at me and said, don't you ever do that again in my courtroom, Missy. And I'll never forget it. I can picture him as if it were yesterday.
I can't imagine anyone doing something like that to you, Rikki. So as I was kind of watching the arguments, it occurred to me that it feels like to me that the prosecution has a particular uphill battle legally because of the self-defense defense. And I wondered if what the prosecutor was trying to do is argue in a legal way what many of us have been thinking, which was kind of like, if you didn't go there with a gun in the middle of this chaos, none of this would have happened. Now, that's not a legal argument, but it's an emotional one. And that's what it felt like he was trying to sort of argue towards, that, well, why would, how did you think this all was going to end up when you made XYZ decisions that found you in the middle of this chaos with a gun?
Well, I think the prosecutor did go there, and I think the prosecutor correctly went there. That the entire idea of this 17-year-old boy who decides to go across state lines and says he's there to render aid as a medic, even though he is not a certified EMT, and that he really basically doesn't render much aid since the only thing he has with him is some gauze. And to say that he's there to protect property, but he carries with him an AR-15 type weapon on a sling and is marching up and down the streets with that weapon. The reality is just your question. Well, what did you think was going to happen? And the difficulty, of course, is that he's not on trial for stupidity. He is not on trial for bravado. He's not on trial either for thinking, perhaps very sincerely, that he was going to be a good Samaritan. He's on trial for killing 2 people and gravely wounding another, and other reckless endangerment for shooting that weapon. So what the prosecutor is trying to do, which he did do somewhat successfully in the afternoon, is to paint that picture of a very reckless 17-year-old who wanted to be a police officer, who wanted to be a big man. And a lot of that came through in the cross, where he pointed to the idea of, well, why the AR-15 weapon? And the fact that Kyle Rittenhouse said, well, it looked cool. He pointed to it on the basis of cross-examination when the prosecutor was dealing with the fact of this TikTok page of Kyle Rittenhouse's and in his trying to show that he was a big, tough guy with this big weapon. Now, I don't know how far that goes with jurors. I really don't. And you also have to remember that we apply, from where we are, some East Coast New York sensibility. Wisconsin is a big hunting state. Wisconsin is a place where a lot of people have legal guns that they use in a very legal and law-abiding manner. So to a lot of these citizens, they may not see anything wrong with the idea of coming to these protests where there was looting, where there were businesses that were burned. CarSource, where Kyle Rittenhouse goes, lost 100 cars the night before for them being put on fire through arson. So there were people, including witnesses that have been called, who came to this area to try to keep the peace and protect businesses with their weapons. That's a very foreign sensibility for someone who lives in New York. It is not foreign for the great part of the Midwest and the West and the South.
So, Rikki, there is some drone footage that shows Rittenhouse shooting one of the victims, but his lawyers are arguing that zooming in on the video could distort the image. Help me understand the legal strategy here, and I just don't understand what they're trying to suggest there.
What they're trying to suggest is that a picture may be worth 1,000 words, but the picture itself gets distorted if you see it through an iPad, that it is then projected, which they are saying because of algorithms in the Apple products, that it's a different image than what actually happened in real life. Now, the judge didn't quite understand that argument. I don't know that I quite understand that argument, nor do you. But the reality was the judge put the burden on the prosecution to say, if you want to use this iPad image, then you're the proponent. You're offering the evidence, Mr. Prosecutor, Mr. Binger. Then you have to get me an expert that says that it is not distorted. It's interesting because we have certainly, as the prosecutor correctly pointed out, we all live with the, if not an iPhone, an Android phone, if not an iPad, some other kind of tablet. So we think that what we look at is, as the lawyers have to say, a fair and accurate representation, which it may be or it may not be. One of the things, Vlad, that I think is an important lesson for your viewers is this. The concept of time is elastic. So I'll give you the easy life example. You're driving down a highway and you've driven the last 2 miles or 5 miles and you go, wow, I just drove those 5 miles. And it seemed like it was just a minute. And the person next to you in the car said, a minute? It seemed like it was an hour. So we have this concept of time being elastic. The prosecution must make this what I call slow time. And the defense must make this really fast time, because the faster all of this occurs gives lots of credence to Kyle Rittenhouse's claim of self-defense. The slower it occurs gives much more credence to the prosecution's look that he did not act in self-defense. It's a very interesting concept.
Rikki, that is so fascinating. So it brings me to my last question before I let you go. So, the nature of the self-defense defense is, how did Kyle Rittenhouse feel sort of the moment before he shot? Not the day before or the week before or even a few hours, but did he feel like his life was threatened right before that? And there's an awful lot of video evidence in this case. Who do you think this helps? Or does it have the possibility of helping and harming both sides?
It definitely has the possibility of helping and harming both sides, which is why I talk about slow time and fast time. Ultimately, the burden of proof in a criminal case is all on the prosecution of proof beyond a reasonable doubt. Here, the prosecutor must prove that Kyle Rittenhouse did not act in self-defense beyond a reasonable doubt. Though, as I often have felt, once you put that defendant on the stand, if you are the defense lawyer, the burden of proof may psychologically for the jurors go simply right out the window. And the only thing that the jurors will talk about is not each element of proof, but did they believe the defendant and did they like the defendant?
Interesting questions. Rikki Klieman, so great to have you here. Thank you.
Thank you.